Welcome back to the morning show here on Arise News. The governorship election petition tribunal sitting in Enugu State has upheld the election of Governor Peter Mbah of the People's Democratic Party in the March 18 governorship election. The three-member panel of the tribunal, led by Justice Kudirat Murayo, dismissed the petitions of the Labour Party and its candidate Chijioke Edeoga, insisting that they could not prove their petitions. In dismissing the petitioner's petition, the tribunal declared that the National Youth Service Corps discharge certificate is not a qualification to contest a governorship election. Edeoga is challenging the return of Mbah as duly elected governor of Enugu State on grounds of submitting a forged NYSC discharge certificate over voting, among others. Joining us now to review the judgment is Inibehe Effiong, a lawyer. Good morning, Inibehe. Good to see you again.
Good morning, Dr. Bati.
I see your luxurious beard is back. You know, your hair
it's fully
is back. After this.
That's true. That's true.
And you are back on television.
Oh, yes.
Well, when there is life there.
Thank you.
Yeah.
Very quickly. Yeah, Enugu Tribunal, the decision in that petition, three major grounds. And they are, the judges looked at the three issues. One is about the NYSC. The second is about qualification. The third was whether, there had been any non-compliance with the provisions of the Electoral Act. But I saw that on social media, you took issue with the first ground about the NYSC certificate. And you asked a simple question. You said, is that the issue in this matter?
Yes.
And from my reading, I thought you were talking about forgery. But their lordships were saying that, look, in that particular matter, NYSC certificate is not a statutory requirement, and that same was not attached in the candidate's form EC9, with regard to his qualification. So when you said, is that the issue, because forgery was also not proved by the petitioners, because the ruling also talked about grounds on which you can, prove forgery before a court of law. Were you expecting the tribunal in this particular instance to go on a voyage of discovery?
An interesting question. Again, it's good to be back here. I have read the judgment. It is a 145 pages judgment. There was no dissent. I read it the first time, and I thought maybe I had not read it well. And I read it a second time. And even this morning, I had to look at the judgment again. Now, my honest answer to your question is that, first, I do not agree with the pronouncement of my lords, with profound respect, regarding even the issue of whether the petitioners had proved that Mr. Peter Mbah had submitted a forged NYSC certificate to INEC. Now, there are several layers to it. And for one to understand this judgment, two sections in particular, which the tribunal spoke to extensively, have to be considered. One is the provision of section 177 of the Constitution, which speaks to qualification. Namely, that for you to be run for a governor, you must meet the age requirement. I think it's 40 now. 2, you have to be a citizen of Nigeria by birth. 3, you must be a member of a political party and be sponsored by that political party. And then, those are basically the basic requirements. And you must also attend school certificate level or its equivalent. Now, Peter Mbah, in his reply to the petition, made out a case that he has the qualification in terms of academics, is a lawyer and so on. But as I said on social media, that was not the issue. The issue is not whether Peter Mbah has 20 PhDs. The issue is not whether he has 100 degrees. The issue is when he put himself forward to run for the position of governor of Enugu State, did he present a forged certificate to INEC? Now, my lords said that because possession of NYSC certificate is not a precondition, it's not a qualifying requirement under Section 177, whether he had even submitted it or not cannot be the basis to say he's not eligible. But with proper respect to my lords, the requirement of qualification under Section 177 cannot operate to undermine the disqualifying conditions under Section 182, which is that one, you must not be a convict in respect of an offense involving dishonesty or fraud. Two, that you have not presented a forged certificate to INEC, and several other disqualifying requirements. But the one that is material, which was the issue before the tribunal, is 182J. Now, what happened? Peter Barr, in his form EC89, of course, filed these academic qualifications. But note that in that, if you look at that form, you are required to attach certificates in proof of your eligibility. Now, in his own case, he attached his NYSC certificate. He did. The tribunal made that finding, but they went further to say no, that he did not specifically mention NYSC certificate as what qualifies him. The tribunal said, well, because he has other academic qualifications that surpasses school certificate level, therefore he is qualified. But with proper respect, I disagree. Because the Constitution does not say if you present a forged degree, PhD, or whatever academic qualification. It says certificate. And Dr. Bati, this is not a new thing. In 2019, in the case of Wabo and Bololo, right? This same issue came before the Court of Appeal, where in that case, it was found that the first respondent had presented 3 certificates. 1, a degree which he claimed he obtained from LASU. 2, a master's degree. 3, an NYSC certificate. All these certificates were shown not to have emanated from the institution through which the first respondent in that case claimed he obtained them, including that of the NYSC. Guess what? Just like in the Enugu case, in this case that I have cited to you, the evidence in that case that was used to establish that the first respondent presented a false certificate was through a witness on subpoena. Because the tribunal went ahead to say that even though the director of course certification in NYSC had testified in favor of Chijioke, right, and the Labour Party, that because his statement on oath was not front-loaded, they cannot look at his evidence. I disagree. Because in that case I have cited, it is also the NYSC that came forward to tender letters written to it where they had disclaimed the certificate presented. So when you say that because the director of course certification, his statement on oath was not filed along with the petition, therefore you cannot examine his evidence, you are asking a petitioner to do the impossible. Because as at the time of filing the petition, I mean, what are we talking about? Yeah. Does the director of NYSC work for the Labour Party? He doesn't work for the Labour Party. They could not have listed him at the time of filing the petition.
Before we go further, if you look at that same judgment by the tribunal at pages 49 to 53, this same matter of NYSC was addressed by the second respondent. The second respondent in this particular case being Peter Barr. And the witness in that particular case, as recorded by the court, said there had been a high court judgment, which was a decision in rem with regard to this same NYSC certificate, which inured in the favor of Peter Barr. And that too, he attached to his from EC9 an NYSC certificate, which was not a piece of surgery. Now, after looking at issue 1, which had to do with qualification, in their conclusion, their lordships did not refer to forgery because they said, look, this is of no moment in this particular case. And you are saying that, okay, and the court, I thought, must have said that witness at pages 49 to 53 must have told them something that they considered worthy.
No, if you read that judgment.
Yes, I've read it.
Yes, the issue of the High Court judgment.
Yes.
said to have been given in rem, the
Yes.
judgment you have referenced, had no bearing on the judgment. There is no page of that judgment where my lords relied on that decision. This was the case of the second respondent. This was the argument of their lawyer in their written address. Lawyers can argue anything, but it is left for the courts to determine the basis of their decision. And I'm saying it on record.
But the matter was before them.
Yes, I'm saying it on record that in their decision, the issue of the High Court judgment never came up, except that the lawyer to the second respondent cited it. They never relied or considered it as a basis for their judgment. But in any event, that couldn't have been the position, because you cannot raise the issue of res judicata to say that Labour Party or the petitioners were bound by that judgment, when that judgment was, the parties may not have been the same, the issue was not the same, and this was a court properly constituted. So that couldn't have been the basis. On the issue of whether it was proved or not, again, with proper respect to my lords, I thought that the petitioner had done their work, because it is the NYSC, Dr. Bati, don't forget that. It is the NYSC that came to court, not just any staff. Director of Court Certification. Right. He came to court and gave this evidence based on the subpoena issued by the tribunal itself. So for the tribunal to say that we cannot look at his evidence, because at the time of filing the petition, his statement on oath was not filed along. Dr. Bati, it is not possible.
Hence the question.
It is simply impossible.
Yes.
And I have cited a division of the courts where the courts have, in fact, in one of the cases, the court said it to be preposterous to demand a petitioner at the time of filing the petition to front-load witnesses. And they rely on the Peter Obi's case. Peter Obi and INEC, the Tinubu case, where the Court of Appeal also discountenanced witnesses of Peter Obi. But guess what? If you look at page 97 of the judgment in Peter Obi versus INEC and Tinubu, the learned justice of the Court of Appeal, the 5-man panel, made a point that those witnesses on subpoena by Peter Obi, they drew a distinction and asked the question, were they official witnesses? Were they adversaries, official witnesses? If these are official witnesses or witnesses that are adversarial to you, how do you expect me, when I'm filing my petition, to go to NYSC and say, come and be a witness to me without an order of court? The Court of Appeal in Peter Obi's case made that point. The question is in Peter Mba's case and Chijoke's case, was the Director of Court Certification an official witness? The answer is yes. Because if you are saying that at the time of filing the petition, that the director who came to certify for Labour Party in that case, supine on the order of the tribunal, that the evidence should have been front-loaded, you are asking the petitioner to do the impossible.
Well, all of these issues will be part of the appeal.
And then, Dr. Bati, that is not even the end of the matter. That is not even the end of the matter. He was not the only one whose evidence was discountenanced. The petitioner actually called 5 witnesses in proof of the issue of NYSC. And the courts have held. And the other aspect is that they said he did not prove it because the original certificate was not tendered. That for you to prove forgery, you must tender the original certificate. With proper respect, Dr. Bati, I don't understand that. If I step out of this studio, let's even use common sense, and say, I am Dr. Rubin Abati. This is my certificate bearing that name. I work with Arise
We're in
TV.
the age of artificial intelligence.
There are 2 ways.
Anybody can claim anything.
Yes, the Court of Appeal has said, in Agi and PDP.
Yes.
Supreme Court, in Agi and PDP, define forgery as the act of making a false document or altering a genuine one. So forgery arises in 2 instances. One is where you make a false document, which was the case of the petitioners in this case. The second is where you alter a genuine one. If I don't work with Arise TV, and I present a letter of employment from Arise TV, and you go to court, can I not be tried for forgery? Will the court now say I must bring the original certificate, which is not in existence?
An impersonation.
Yes, it doesn't exist. So you can, the tribunal, with proper respect, I don't agree that to hold that the petitioner should have tendered what does not exist.
All right.
Okay, Inibehe. Thank you.
Thank you very
so
much.
Inibehe, thank you. We'll see what happens when the matter goes on appeal. Okay?
Thank you.
Thank you. We take